So here's some basics before going into the Supreme Court case that basically show regarding certain current events about people putting things in their face or not, and the importance of really knowing the foundation of how quote unquote this system works. Too often do you find people going on about this system, that system, law this, law that. But if you do not know the basic of how this thing was, then you will never be able to shape the future about how it interfaces with you, whether it's to your detriment or not, whether it's to your children's detriment or not. Here's the United States of America Congressional Record, 9th Congress, First Session, Volume 113, Part 12, June 12, 1976, regarding the 14th Amendment and whether it's valid or not. Keep in mind, this is the United States Congressional Record. This is not some mere spurious opinion or some subjective stuff that's being thrown at you. Meaning you can go right now to official publications and get a certified copies of this, or cross-reference this with other facts according to the things that are preserved by official entities that some people love but some people hate. That is not how you feel about one entity or another. What is written in black and white exists for a good reason, and you should put it to use. Page 15641 tells you. Remember, this is congressional records, by the way. Congress is the body, the government that makes the law. Keep that in mind. And here's one of the speakers in the House. 14th Amendment, equal protection of law or tool of usurpation. So since the legislative branch of the government makes the law, how a law is made, they're ratified. Once the laws are ratified, they become enforceable and applies to everyone who qualifies under it. That's the basics of it. And here are the speakers of the House having a discussion as to this thing called the 14th Amendment that many people run about going to court and try to use as their basis as to why they can do one thing or why others cannot do one thing to them. Goes, Mr. Speaker, I ask unanimous consent that the gentleman from Louisiana, and by the way, the United States basically is just a conglomerate or the come together of all the different states. Georgia, Texas, Illinois, New York, Massachusetts, all of them coming together as a body politics to become one and operate as one mind. So in order for any type of law to be created under the United States of America, or United States as it's become now, they all have to each agree with it and pass a resolution independently saying, yep, we agree, or we don't agree. There's certain representatives from each of those states that come together under the banner of the United States that represents their respective states to say, yep, I'm speaking on behalf of the state of this or the state of that, and we agree. We're going to put our hands on this, we're going to co-sign it, we're going to undersign it, we're going to underwrite it, and say, yep, we want this to be law. That's the will of the people in the state of so-and-so. And if there's enough votes, according to Article 5 of the United States, which basically lists how laws are created in the United States of America or in the United States, then it goes. There's a certain amount of votes. So it's here, Mr. Pryor. Mr. Speaker, I ask unanimous consent that the gentleman from Louisiana may extend his remark at this point in the record and include extraneous matter. Go down to the interesting part. Through the corporation of intellectual educators, we have subjected ourselves to accept destructive use and meaning of words and phrases. To blindly accept new meanings and change values to alter our traditional thoughts. We have tolerantly permitted the habitual misuse of words to serve as a vehicle to abandon our foundations and goals. Thus, the present use and expansion of the 14th Amendment is a shame-serving as a crutch and hoodwink to precipitate a quasi-legal approach for overthrow of the tender balance and protection of limitation found in the Constitution. All those fancy words are just saying the 14th Amendment is unconstitutional, and we are just loosely going along with it like it's actually real, when in truth it is not, and we are screwing ourselves over. These are the people within the Congress talking to themselves, discussing what they're going to do with this thing called the 14th Amendment, because there is a dispute as to whether it's been passed or not. But interestingly enough, the 14th Amendment, whether ratified or not, which is how it turns into law, any type of proposition that is not ratified is not law, was but the expression of emotional outpouring of public sentiment following the war between the states, meaning some states wanted to join the Union and become the United States, some didn't. Some states, screw this. We want to have our own thing and stay as an independent body politic. We want to remain sovereign. We don't want to join the United States and render our sovereignty to another body politic. So a war broke out. And guess what? They proposed something called the 14th Amendment, which creates a whole new entity of its own through those states. There's the same name and all, different powers and different purpose. Some agreed, some didn't. Its obvious purpose and intent, and basically when you hear people talk about the states being the first 14th Amendment citizens, this is what they're referring to. And this is basically talking about it, and that's why the states went to war against one another. These are the hidden stuff about how this thing works, this world works in North America that many people are not familiar with. Many people go to colleges and universities and are clueless of this basic things. You will have a full-blown conversation with somebody with some bachelor's or master's in political science, and they are absolutely clueless about these basics. That's concerning. Then goes on to say its obvious purpose and intent was but to free human beings from ownership, aka slavery, as a chattel's property, serfdom, by other humans, slavery. Its aim was no more than to free slaves. There we go. As our politically appointed federal judiciary proceeds down their chosen path of chaotic departure from the people's government, and the power created by the will of the people slowly being taken away and being turned into something else, by substituting their personal law rationalized under the 14th Amendment, meaning the 14th Amendment is not ratified, it is not by the will of the people. It's created by something else foreign to the will of the people. Their actions and verbiage brand them and their team as secessionists, rebels with pens instead of guns, seeking to divide our union. The union was created by the Articles of Confederation. They must be stopped. Public opinion must be aroused, and the people must know about this. Something is going on that only a very few people are privy to, and the everyday man and woman that are going on by their daily lives who think they finally obtained some freedom have no clue that they are being usurped. That's what this is talking about. The Union must and shall be preserved. Mr. Speaker, I ask to include in the record, following my remarks, House Concurrent Resolution 208 of the Louisiana Legislature urging this Congress to declare the 14th Amendment illegal. Now, why would they bring in Louisiana's resolution to the United States? Keep in mind again, each state are their own body politic. They're their own government. That's why they have their own governor, their own senator, all that. They're their own independent body that operates independent of one another. And the Union is basically the United States. In order for you to unite, that means there must be an independent bodies that are coming together. So in order for a decision to be made within those within that united body, you have to consider what is going on based on what makes up that united body. In this case, they're calling upon the intention of the United States legislature to the legislature of Louisiana, saying, look, we don't agree to this. This is not right. The people don't agree to this. So here's an evidence of what's going on according to our body politics. If we're really part of this thing called the Union or the United States, here's what we're saying, and we're using our legislature to say, look, this is not right, and if we're part of this, you have to put this into consideration, and this is where we stand. Then goes on to say, also, I include in the record an informative and well annotated treatise on the illegality of the 14th Amendment, meaning he's bringing in straight law and admissible evidence. And who's speaking? This is Mr. Rarick, the gentleman from Louisiana, the play toy of our secessionist judges, meaning the judicial system has already been overtaken at this point. The Judiciary Act, which he loosely made reference to right here. Federal judiciary proceeds. Look it up, the Judiciary Act. That's how they overturn the court systems, in modern times at least, here in North America. Then it goes on to say, which has been prepared by Judge Linder H. Perez of Louisiana. The material referred to follows House Congress Resolution 208 of Louisiana, that is, which says a concurrent resolution to expose the unconstitutionality of the 14th Amendment to the Constitution of the United States, to interpose the sovereignty of the state of Louisiana against the execution of the said amendment in this state, to memorialize the Congress of the United States, to repeal its joint resolution of July 28, 1868, declaring that said amendment had been ratified, and to provide for the distribution of certified copies of the resolution. This automatically tells you that each state has a power of its own. So don't overlook that state constitution. If you want to bring any claim based on any current event going on, you better start looking at your state constitution, because that is what preceded the United States. The United States Constitution finally, finished working on in 1791. If you look at each state constitution and their first constitutions, you realize many states, North Carolina, all these other states, have constitutions that predate 1791. That should start to raise a flag on what and who really has power. Whereas the purported 14th Amendment to the United States Constitution was never lawfully adopted in accordance with the requirement of the United States Constitution, because 11 states of the Union were deprived of their equal suffrage in the Senate in violation of Article 5, when 11 southern states, including Louisiana, were excluded from deliberation and decision in adoption of the joint resolution proposing said 14th Amendment, meaning the process of actually ratifying any law was not followed, which is stipulated in Article 5 of the United States Constitution. Because of that, the 14th Amendment was never lawfully adopted according to the Constitution of the United States itself. So now if something is being used that is contrary to the requirements of the Constitution of the United States itself, then that means you yourself are going against the Constitution of the United States if you're using 14th Amendment. Stop for a moment and put that into consideration. And they are telling you right here, this is admissible evidence, congressional records, that you can pull up at any time and get certified copies of it, and use rules of evidence regarding self-authenticating copies and bring it into evidence. And if you're going into any type of public or private courts and you're claiming 14th Amendment as what gives you the right to do something, aka 42 U.S.C. 1983, read the public law version of 42 U.S.C. 1983 and you see that it's predicated upon 14th Amendment. If you go into any courts or you're just using 14th Amendment directly, the people that you're talking to, that you're saying, hey, I have the right to do this because of the 14th Amendment, or because of 42 U.S.C. 1983, and so on and so forth, they know this. They know about this congressional records. But guess what? It's not their responsibility to educate you on the law. You're supposed to know about this and act accordingly. You're saying you have rights, right? then you ought to know about everything that entails that right. Again, whereas the purported 14th Amendment, purported just means a supposition, something that's not substantiated, something that's still somewhere in the air. The purported 14th Amendment to the United States Constitution was never lawfully adopted in accordance with the requirements of the United States Constitution, because the 11 states of the Union, 11 of them, were deprived of their equal suffrage in the Senate in violation of Article 5. When 11 southern states, including Louisiana, were excluded from deliberation and decisions in the adoption of the joint resolution proposing said 14th Amendment, said resolution was not presented to the President of the United States in order that the same should take effect as required by Article 1, Section 7. The proposed amendment was not ratified by 3/4 of the state. These are your tools right here that lets you know that the 14th Amendment is not a law. 11 of the State of the Union did not even make a decision on it. That's one. Two, the resolution that they proposed to make the 14th Amendment law was not presented to the President of the United States in order for it to even take effect, according to Article 1, Section 7 of the United States Constitution. This is the process of how law is made on the United States level, and it was not followed at all. The proposed amendment was not ratified by 3/4 of the state. That's the third point right there. It's the third requirement to make a law. But to the contrary, 15 states of the then 37 states of the Union rejected, 15 of them rejected the proposed 14th Amendment. So 11 of them were excluded. It wasn't proposed to the President as required by Article 1, Section 7. And it was not ratified by 3/4 of the states, because most of them rejected it. Between the dates of its submission to the states by the Secretary of State on June 16, 1866 and March 24, 1868, thereby nullifying said resolution, and resolution meaning the proposition of the 14th Amendment to be made into law, thereby nullifying said resolution and making it impossible for ratification by the constitutionally required 3/4 of such state, and said southern states which were denied their equal suffrage in the state, meaning their right to vote. Remember women's suffrage, women's right to vote, all that? Well, each state being their own independent bodies making up the United States have the right to make a decision as to what laws govern them if they're part of that organization. They're not given that right. Which were denied their equal suffrage in the state had been recognized by the proclamation of the United States to have duly constituted governments with all the powers which belongs to free states of the Union, and the legislatures of 7 of said southern states had ratified the 13th Amendment. Now, in the 1800s, around this time, the 13th Amendment they were speaking of is the one that spoke about Africans not being slaves and that slavery was permanently abolished. Not the one that you will see now, which would have failed of ratification but for the ratification of said 7 southern states. And whereas the Reconstruction Act of Congress, this is where they basically usurped people who originally ran the Congress and basically changed the faces. People who ran it still look the same way. The people who currently run the North American government still looks the same, but the faces are just different. And that's a whole nother story. Unlawfully overthrew their existing governments, removed their lawfully constituted legislatures by military force, and replaced them with rump legislatures which carried out military orders and pretended to ratify the 14th Amendment. So if you hear somebody talking about, oh, well, it's a lie, it's a rumor, it's not true that Reconstruction era took place, and well, here's a congressional record telling you that it did. This has been unrebutted. This was published. It's an official publication. And there's even a I don't know if it's South or North Carolina. It was one of the last formal Republican president where they sieged the headquarters of the state capitol. And he wrote a letter to one of the military generals resigning. I have that handwritten letter. It's somewhere, but you can look it up. All this stuff exists. Whereas, in spite of the fact that the Secretary of State in his first proclamation on July 20th, 1866 expressed doubt, meaning they were doubtful about what the 14th Amendment was or not. All the people going on about, what's it called, martial law, that stuff took place long ago. Martial laws coming, this and that. That stuff has been in place a long time ago. Congress nevertheless adopted a resolution on July 28, 1868, unlawfully declaring that 3/4 of the state had ratified the 14th Amendment and directed the Secretary of State to so proclaim, meaning if they really did ratify it, there will be a signature somewhere showing you all that stuff. You would never find a true copy. Meaning, okay, you don't find the original copy, no problem. Where's the copy of the true one then? Showing all the signatures, 3/4 of the state ratifying it and agreeing to. You will never find it. Said joint resolution of Congress and the resultant proclamation of the Secretary of State included the purported ratification of the military enforced rump legislation of 10 southern states whose lawful legislatures had previously rejected said 14th Amendment. Wow. So these states had their legislature saying, look, we don't agree to this 14th Amendment and we're not putting our hands on it. And also included purported ratifications by the legislatures of the states of Ohio and New Jersey, although they had withdrawn their legislative ratification several months previously. Ohio and New Jersey didn't even agree with it. All of which proves absolutely that said 14th Amendment was not adopted in accordance with the mandatory constitutional requirements set forth in Article 5 of the Constitution, and therefore the Constitution itself strikes with nullity the purported 14th Amendment. These are tools you can use. Great tools that you can use. If only you know how powerful this is, you will stay away from that 14th Amendment. Now therefore be it resolved by the legislature of Louisiana, the House of Representatives, and the Senate concurring, that the legislature go on record as exposing the unconstitutionality of the 14th Amendment and interpose the sovereignty of the state of Louisiana against the execution of the 14th Amendment against the state of Louisiana and its people. That the legislature of Louisiana opposes the use of the invalid 14th Amendment by the federal courts to impose further unlawful edict and hardship on its people. The Congress of the United States be memorialized by this legislature, meaning it's permanent. Memorialization is when you keep record of something permanently. Like when you memorialize somebody's grave and stuff like that, they're doing this. They're keeping a record of it. And they're superimposing their legislation right into the congressional record. They knew what they were doing. That the Congress of the United States be memorialized by this legislature to repeal its unlawful joint resolution of July 28, 1868, declaring that 3/4 of the states had ratified the 14th Amendment to the United States Constitution. That the legislatures of the other states of the Union be memorialized to give serious study and consideration to take similar action against the validity of the 14th Amendment, and to uphold and support the Constitution of the United States, which strikes said 14th Amendment with nullity, and that copies of this resolution duly certified together with a copy of the treaties of the unconstitutionalities of the 14th Amendment by Judge L. H. Perez be forwarded to the governor and secretaries, blah, 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 blah. This was not opposed. Then goes on to read that the United States Constitution provides Article 1, Section 3. The Senate of the United States shall be composed of 2 senators from each state. Article 5. No state without its consent shall be deprived of the equal suffrage in the Senate. None of this was abided by. wasn't even given to the president to go over it, to make final determination as to whether it's law or not. So it was never ratified. Here are the steps again. "11 of those states were not even given the opportunity to make the decision." That's one. And along those same lines, 2 of them, which is Ohio and New Jersey, withdrew their consent to the 14th Amendment and said, nah, we don't know about this. That's 2. Three, said resolution was not presented to the President of the United States in order that the same should take effect. According to Article 1, Section 7, meaning, all right, so all of us have voted, now let's propose it to the United States President, which is the CEO of this State of the Union. It wasn't even given to the President. That's 3. The proposed amendment was not ratified by 3/4 of the states. That's 4. So the 14th Amendment is not law. And it is right here in congressional records. It is available to everybody. So it goes on to just show more evidence and more details of it. And then if you want, you can go to each of these states' legislature around these time, and you can pull the records that they're clearly and unequivocally letting you know, look, we don't agree to this 14th Amendment, so we're now voting for it. And one of them was Georgia. You can obtain a certified copy of that decision. Here's a certified copy from Georgia. A memorial to the Congress of the United States of America, urging them to enact such legislation as they may deem fit to declare that the 14th and 15th Amendment to the Constitution of the United States were never validly adopted, and that they are null and void and are of no effect. Keep in mind, I, Christopher M. Davis, the director of Georgia Archive. This is Georgia Archives now. Do hereby certify that the 3 pages document hereto attached and made part of this certificate is a true and correct copy of the entire file for Act Number 45, Senate Resolution 39, approved March 8, 1957. A memorial to the Congress of the United States of America, urging them to enact such legislation as they deem to declare that the 14th and 15th Amendment to the United States was never validly adopted. Whereas the state of Georgia, together with the 10 other southern states, declared to have been lately in rebellion against the United States, following the termination of the hostilities in 1865, met all the conditions laid down by the President of the United States in the exercise of his constitutional powers to recognize the governments of states, domestic as well as foreign, for the resumption of practical relations with the government of the United States, and at the direction of the President did elect senators and representatives to the 39, blah, 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 blah. Whereas, when a duly elected senator or representative appeared in the Capitol of the United States to take their seats at the time for the opening of the 39th Congress, and again at the time for the opening of the 40th and 41st Congress, hostile majorities in both houses refused to admit them to their seats in manifest violation of Articles 1 and 5 of the United States. Meaning, some of the people in the State of the Union were not allowed to even sit to make any decision. That's the violation automatically right there of Article 1 and Article 5 of the United States Constitution. They're laying it out to you right here. Louisiana already put theirs directly into the United States Constitution, and they give it a reference that you can go get a copy of yourself. And here is Georgia stating theirs, and there are other states that say the same. Whereas said Congresses, not being constituted of senator representatives from each state as required by the supreme law of the land, were not in constitutional contemplation anything more than private assemblage unlawfully attempting to exercise the legislative power of the United States. And whereas the so-called 39th Congress, which proposed to the legislature of the several states an amendment to the Constitution of the United States, meaning they were effectively tweaking the substance of it, known as the 14th Amendment, and the so-called 40th Congress, which proposed an amendment known as the 15th Amendment, were without lawful power to propose any amendment whatsoever to the Constitution. They're making it so clear and plain. Whereas 2/3 of the members of the House of Representatives and of the Senate, as they should have been constituted, failed to vote for the submission of these amendments. And whereas all proceedings subsequently following from these invalid proposals, purporting to establish the so-called 14th and 15th Amendments as valid parts of the Constitution, were null and void and of no effect from the beginning. And whereas, furthermore, when these invalid proposals were rejected by the General Assembly of the state of Georgia and 12 other southern states, as well as of sundry northern states, and the so-called 39th and 40th Congress, in flagrant disregard of the United States Constitution, by the use of military force, dissolved the duly recognized state government in Georgia and 9 of the other states, and set up military occupation or puppet state government. They're letting you know, which completely ratified the invalid proposal, thereby making the point of bayonet, meaning under duress, threat, and coercion. Remember principles of the contract? Meaning one day nobody even ratified it as required by the law. They just strong-armed it into a piece of paper. A mockery of Section 4, Article 4 of the Constitution, guaranteeing to every state in the Union a republican form of government, and guaranteeing protection to each of them against invasion. Letting you know something has been usurped through warfare, through military power. And doesn't each state constitution tells you that military power shall be subordinate to civil powers? Of course it does. So it goes on. And this is not just there's a signature right there, the original signatures. So you can look into each state legislation that lets you know similar verbiage that, look, this 14th Amendment is not law. And even if you don't want to go through all that effort, here's the congressional records that states it. None of these have been overturned, redacted, argued against, none of that. So if you're coming in wanting to use the 14th Amendment as the basis of your claim, just know that you are perceived as being a fool. Just keep that in mind. And similar ones, for instance, in Texas, instead of going through it and reading it, here's a reference to it in Texas, Journal 429, the State Library, Austin, Texas, House of Representatives, 11th Legislature, State of Texas, Unified and Library and Historical Commission, 1866. Similar thing was mentioned here, so go read it. It's right there. And interesting enough, this is a letter written by one of the last, now when I use the term Republican, I'm not talking about the modern party system, Republican, Democratic. Because when you look at this, back then, there were Federalists, there were other types of parties, and many different parties, but that's not what I'm talking about. When I talk about Republican, I'm referring to Article 4, Section 4 of the United States Constitution, that form of government. So the last Republican governor, around the same time all that stuff was happening, the 14th Amendment, not being ratified, a lot of them saying, no, we don't want to ratify this, we don't care for it. Military occupation was taking place. And this was the last Republican governor Holden at, I think it was either North Carolina or South Carolina. This was a letter of his resignation that he wrote. You'll find it in the state archive in South Carolina or North Carolina, I forgot which one it was. That is basically saying, okay, all right, he's writing a letter to one of the United States military generals and saying, all right, I see you got your armed men in front of the state capitol, and you got somebody here that is to take my place. This is the handwritten copy. Here's the typed version. North Carolina. Typed version of it. Read it. Lets you know. At sundown yesterday evening, I received from Colonel William, commandant of this military post, an extract from the General Orders number 120. The general can be as follows. Facilitate the organization of a new state government. The following appointments are made to be governor of the North Carolina. W.W. Holden, governor-elect. Vice Jonathan Ward, removed to be lieutenant governor-elect of North Carolina. Todd R. Caldwell, lieutenant governor-elected to fill our original vacancy, to take effect July 1st, 1868, for the meeting of the General Assembly of North Carolina. That's just a reference. So this is the letter he's making reference to. And then he goes on to say, I do not recognize the validity of the late election, meaning they are self-appointing their own thing, their own man or woman in that position, without any formal election. And he's saying, look, I got your letter, you're a military general, and you're writing a letter to me saying that you've appointed some guy in my place. It says, I don't recognize the validity of the late election, under which you and those corporating which you claim to be invested with the civil government of the state. Then the United States is now taking over each independent state that has their own independent power. It's using military powers to take over them. And it's giving them notice that, look, we don't care what you say. We got the guns, we got the bombs. What's up? The governor is saying, look, I don't recognize the validity of the late election under which you and those corporating which you claim to be invested with the civil government of the state. You have no evidence of your election, save the certificate of a major general of the United States Army. I regard all of you as, in fact, appointees of the military power of the United States. I'm telling you right here, and not as deriving your powers from the consent of those you claim to govern. Right there. And Illinois tells you in Article 2, Section 1 that the consent of the government is required. The government are instituted by the power of the people. And that's what this governor, the last public and formal government, is affirmed by Article 4, Section 4 of the United States Constitution. And North Carolina is saying the same thing. Knowing, however, that you are backed by military force here, which I could not resist if I would, I do not deem it necessary to offer a futile opposition to vacate the office without the ceremony of actual eviction. Offer no further opposition than this, my protest. I will submit to actual expulsion in order to bring before the Supreme Court of the United States the question as to the constitutionality of the legislation under which you claim to be rightful governor of the state, and they use military power to basically usurp each state. And this guy's letting them know, look, this is not constitutional. You didn't go through any formality of election, and you're just writing me a letter saying, well, we've appointed this guy now, and he's in your place. And he's saying, well, no, you didn't, but I see you got men here with military powers, so I mean, what else can I do? That's what he's saying. I surrender the office to you under what I deem military duress. This is record that's saying this contract is invalid. It was done under duress. It's unconstitutional. Believe it or not, this is a very strong and powerful record that you can use without stopping as occasion would well justify. To comment upon this singular coincidence that the present state government is surrendered as without legality to him whose own official sanction 3 years ago declared it valid. I'm very respectful, Jonathan Worth. Jonathan Worth, the guy who they usurped and installed Holden. And this guy, if you look at the things that he did in North Carolina, but that's a whole nother thing. But that's really the summary of 14th Amendment right there. Is there more? Always. There's always more. Do your own research. If you're coming in and relying on the 14th Amendment as your claim, Just know that it was not lawfully ratified, and there's immense evidence that it was not lawfully ratified. And even if there's no immense evidence of all these official records saying it's not lawfully ratified, then simply produce the evidence that it is in fact lawfully ratified. It's as simple as that. So if you want to bring up any claims regarding someone telling you to take a jab or put something in your face, do yourself a favor and stay away from the 14th Amendment. It's not going to serve you well.